We are live.
We are back in Senate Judiciary, switching gears with the forensic facility to talk about the uniform disclaimer of property interests bill that we have, and we have Mark here to testify, and yeah, the floor is yours.
Okay, thank you, Senator. My name is Mark Langen. I am the chair of the probate and trust law section of the Bar Association. I've been here many times before, brought you the Uniform Trust Code, brought you the Uniform Power of Attorney Act, Digital Access Act, so a number of acts. And now I'm bringing you the Uniform Disclaimer Act. And the head of our subcommittee, Matt Gaiman, has already testified. Thank you for giving me an opportunity, because I just want to explain to you very briefly why I think it's important you should pass this act. Let me give you a little history. First of all, disclaimers. Disclaimers is basically saying, I don't want your gift. I don't want your inheritance. You know? And you may not want it for a number of reasons. Number one is, it's toxic land. You may say, I don't need it, and if I disclaim it, it'll go to my kids. Okay, again. So disclaimers have been around for centuries, okay? And then what happened, and we actually had a Uniform Disclaimer Act before 1976. 1976 is very important. It's when Congress passed the Tax Reform Act of 76. And in it, they put a provision, a disclaimer provision in the gift tax section saying, if you're going to disclaim that, and you don't want to treat it as a gift, you've got to follow some rules. And those rules are, number one, you got to do it 9 months within the interest being created. It's got to be in writing. You can't be taking an interest in it. You can't be taking the income for it and say, oh, no, I don't want it now. And you have to deliver your disclaimer, that written disclaimer, to the person who's transferring it to you. Okay? So they did that in 76. Right after that, in 78, the Uniform Laws Commission put out a revision to the Uniform Disclaimer of Property Interest Act. And basically, and we passed it in 86 in Vermont, but what they did back then is they said, they basically adopted that section of the code and say, this is the only way you can make a disclaimer. You have to do it in writing within 9 months of the interest being created, da, 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 okay? And they said that's the only way you could do it. So they crowded out, it shouldn't matter. What if you don't care if there's a gift? You know, the tax consequences of it is one thing, but to have a statute that says you can't even disclaim you're too late is another thing. It's pigeonholing everybody into the tax regime, you see. And so that's why, if for nothing else, that's why this Disclaimer Act is an improvement, because it allows you to disclaim. There's no 9-month deadline anymore. You can disclaim whenever. Now, that doesn't mean you might have adverse tax consequences, okay? And here's why it's important now. Because, yes, you may have made a gift. You say, let's say it's 10 months, and you say, I want to disclaim. And and under the tax code, it will be considered a gift. So what? You got a $15 million exclusion you can use up, and you're probably never going to get there, you know? So we should have the freedom to be able to disclaim after the 9-month period, you know, and it may have gift tax consequences, but most of my clients don't care.
The 15 million is the gift exclusion, meaning that if
it's the gift and estate exclusion.
So if it's above 15 million, then no matter what, you're going to have to pay taxes on it. Is that what you're saying?
Correct. If you eat up your exclusion. I'll digress for you for a second. Here's what happened. Back in the late 70s, the estate tax was higher rate than the gift tax. Okay? So if you knew you were going to die, wouldn't you be smarter to gift it away before you died? So, classic case, my grandfather took out his wallet and threw it to my grandmother on his deathbed, you know, thinking you made a gift. You know, so what happened is the Congress, so people were doing that. And Congress they said, oh, this is cheating. We got to plug up this hole. So what they did is they passed a 3-year rule, and they said that if you make a gift within 3 years of your death, we're going to bring it back in the, if it was made in contemplation of your death, we're going to bring it back in the estate. And so that was 2035 in the code. And what happened is the IRS would pull them back every gift, everything, you know, regardless. Well, a number of people got talked off about that. They said, my parents died in a car accident. They didn't die in contemplation. This was not made in contemplation of death. And so the courts got swamped with these cases, and they didn't know what to do about it. So Congress went back to the drawing map, and they said, look, we're going to do away with this problem. We're going to make the rates the same, and we're going to have one exclusion, and that exclusion back then was $175,000. And it doesn't matter whether you make a gift or if you give it when you die, it's going to eat into that exclusion. Of course, now we have a number of little exclusions. The government doesn't want to be bothered with every birthday gift, you know. So they said, we're going to let you make an annual gift per year per donee of $3,000, you know, and don't tell us about it. Don't file a return, you know. That has since moved up to $19,000 per year per donee. Okay, so and there are a couple others. You can make gifts of tuition, you can give a med on top of that without even telling the service about it. But once you go over that $19,000, you must eat into your exclusion. One guy said, no, I want to pay the tax. I'll pay the gift tax right now, and I want to keep my exclusion in place. The service said, no, you've got to eat your exclusion. No. Why did the service say that? Because when you make a gift, the donor makes the gift. The donor has to, let's say they make a gift of $100,000, they got to come up with extra money to pay that, and that gets it out of their estate. But when you die, you have to pay your estate tax on the very dollars that are in your estate. So it's an inclusive tax. And so the government makes out better in that situation. So we've had this incredible increase in the exclusion since 2019. Trump signed into office the Tax Cuts and Jobs Act, where we went from 5.5 up to 11. We've gone up by inflation since then. And then with the recent Tax Act, we were close to it, but we're now at $15 million per person. So a married couple can give away $30 million to the next generation without incurring the federal estate tax. Now here in Vermont, we have a $5 million exclusion. So we can pass close to $10 million, but okay.
I have a question.
You look like you swallowed something
The
really bad tasting.
actually,
I did.
What?
I'm wondering about if the person who wants to disclaim something with this bill, as it's written, they can disclaim it whenever, right?
Correct.
And can they still gain, and can they still have that interest and potentially generate income from whatever that potentially disclaimed item
Yeah,
is?
of those 4 requirements that I said that were in for the gift tax,
Yeah.
it's only the 9-month. So you can't be taking an interest and then say, oh, I've had enough, I'll disclaim it now. You know, once you take an interest, you've accepted the gift, and therefore you can't disclaim. So you can never touch the gift, you know. And it's got to be in writing, and it's got to be delivered to the transferor. Okay. So those are still. But let me explain to you how difficult this is as far and where our statute falls down. So let's say you have a trust. There were actually 2 cases, and they both dealt with the families that own 3M out of Minnesota. So they had these trusts, and they went for the surviving spouse's life, and then upon the death of the surviving spouse, the remainder went to the kids. And one kid said, one kid said, well, only found out about it when his mother died, that he was going to be getting all this money. And he said, I wanted to disclaim it. And the service said, too late. Because your remainder interest vested when your father died. And that's when the clock started ticking. Even though you didn't know about it until your mother died. several decades later. You know, so sometimes the person who, it's not when you find out you get the interest, it's when the interest is created. And therefore people were excluded from being able to disclaim. Under our act, there's one section where it says that if it's a testamentary act, like a will, then, you know, once that interest is created, you've got 9 months to disclaim, otherwise you're boxed out. So I've got a case right now where it took forever for us to get this estate open. And now I'm told by my paralegal, I mean, it took like a year. And now I'm told by the paralegal it was a gift to a museum of a piece of art. And they said, well, we don't know if we'll accept it. Well, guess what? It's too late under our statute because the interest was created when they died. And even though it took us a year to get the will allowed, that interest was created, it's too late for them. So this act would open that up, the 9 months. And plus, the charity doesn't care, you know, if there's gift tax consequences, because they don't pay gift taxes, only individuals do.
People can give away $5 or maybe $10 million and not have any of that taxed?
It's not subject to, well, you have to eat up your exclusion. So let's say you decide to give away $5 million to your kids. You must file a 709 on the April 15th in the year after the death and say, hey, IRS, I'm using up my $5 million of my $15 million exclusion.
But in the state of, so that's the federal, the 15 million, which is insane. But at the state level, we can transfer $5 or $10 million with nobody paying taxes on it.
We have no gift tax in Vermont, nor does any other state.
Huh, interesting.
So that's it is a very, so what we do have an estate tax. Only 20 states in the United States have an estate tax, 30 do now. We're one of the few, and most of them are in the Northeast. But if someone gives assets away, then that is out of their estate if they give it at least 2 years before they die. Okay, so that's a key thing for planning around the Vermont estate tax. But so I'm giving you the crucial reason why you should pass this act, because we should allow people and institutions to be able to disclaim even if the 9 months has gone by. We shouldn't be shackled by the tax reason. Let the tax reasons be what they are, because they're really non-consequential. But if you'll, I will tick off, if you want, some other reasons why I think that it's a good reason, you know, it's a better act than what we've got. Let me just, I can go through these really quickly. Number one is you can disclaim ahead of time. Your parents aren't dead yet. You can still, you can prepare your disclaimer right now under the act and get it done. There are clearer rules with regard to when you disclaim joint property held as joint tenants with rights to survivorship and tenants not retiring. For example, let's say that Jim puts 60% of the money in the checking account and Amy puts 40%, and it's joint tenants with rights to survivorship, and Jim dies first. What can it's really unclear under Act. What can Amy disclaim? 50%? Because there's two owners, or 60%? The Act makes it clear 60%, because we look at the consideration first. Much better. It's a much more complicated rule explaining which our current statute doesn't do. It allows you to, let's say the trustee has a power of appointment, and it says, I'm giving my kid this share, and it will go in trust for them for their life, but when they die, it will go according to the way that if they can appoint who it goes to. And so this act allows the people who are the appointees under that to decide at that point. So that's not in there. That's a new, there's no equivalent in the Our statute now allows only executors and guardians to disclaim. This would add trustees and agents under powers of attorneys. So I think that's a improvement. This statute would allow parents to disclaim for their children if there's no conflict of interest, economic conflict of interest, and stuff like that. We don't have that in our current statute. And there's no equivalent right now, so that would be an improvement. It allows, it's much more clear about what happens if you want to exercise a disclaimer for your mother, or your mother wants to do it, but she can't sign anymore. She's lost her ability to sign. It has an equivalent provision to the wills that said that you can ask someone to sign for you. That's not in the current statute. This statute says, hey, disclaimer, it's not all or nothing. You can disclaim half. You can disclaim a percentage or half. And if you want, I've jotted down where you can find this in the end if you want to stop me at any time. Just give a couple more. I think this is just brilliant. If you disclaim, and it says under that, let's say you have an IRA, and it says if you disclaim, it goes to your state. Well, then you've tossed all these assets into probate. Well, what this act would do is say, no, it doesn't have to go through probate. It can go to the beneficiaries of who would take under your will if it did go through probate. You can just skip over the whole probate process. This statute only talks about, I said that one of the requirements is that the writing has to be delivered to the transferor of it. And so there was only, in the current statute, it only deals with the delivery with regard to real property. This statute is much better because it's more robust. It talks about, well, what if you're disclaiming an IRA, or what if you're disclaiming an annuity or an insurance policy? It deals with all sorts of different assets. Big improvement. And this asset also incorporates the Electronic Signatures Act, which is super important nowadays, because I find that my clients ask me, do I have to have the wet ink original to give to the bank? And the answer is no, not anymore, because we passed this statute. If you have a PDF and it's got a statute, that's a legally binding signature. So you can control what happens upon disclaimer in an instrument, in which our statute's currently not, it doesn't have that. So for example, I have some clients, and they have two daughters. One is fabulously wealthy, and the other one is not. And the one who is, she just called me and she said, if I disclaim, I just wanted to go to my sister, because my family's rich enough. And I said, well, it's not quite how it works, because I bet you in their document it says if you disclaim, it's going to your kids. So we're going to have to we can deal with the parents, and the parents will say, hey, if she disclaims, it's going to the sister, not down the bloodline. And one other thing is, this makes clear that when you do disclaim, it's not a transfer. Why is that important? Because if you're disclaiming real property, and the transfer tax due, this makes it clear it isn't. It's not clear under our current statute. So it's not a transfer when you do that. Now, there's an exception to the rule, probably, for Medicaid. What's happening on the back end is, I had a client who was on Medicaid, and then someone died and left them a big inheritance. Can they disclaim so they can stay on Medicaid? The answer from Medicaid purposes is no. And that is like, if you got it, you go off Medicaid until you would have used it up. So but that's coming in from a different direction.
So, I'm not trying to make this more difficult, but I suspect, actually I'm fairly confident, this would have to also go through Senate Finance based on some of the things that I've heard here. I don't know if that's residents Senate Finance.
Yeah, that's me.
What's your thought on this?
Just to me offhand, if it affects the revenues of the state, which it sounds like it may, potentially, because if somebody,
No, I don't think that, well, first of all,
because if you miss the timeline and you can't disclaim and you get a bunch of money and if it's over 5 million or 10 million, depending if it's your parents, then there would be a tax due, right? If you weren't able to disclaim, I mean.
yeah. No, because a lot of times when you disclaim, it's deemed to be a gift, and we have no gift tax.
True.
So I think it's totally revenue neutral. I don't think it's gonna affect our coffers at all. I mean, the planning that's done, you know, I mean, we can do some planning that, what we need to do, what our major challenges of estate planners with people with large estates is, my big one is with our exclusion, we still have the rule, if you don't use it, you lose it. So let's say you have a couple with $10 million. One's got 7 million and the other's got 3. If the person who dies first has 3, then you've lost $2 million of exclusion you could have passed on to your kids. Because if you don't use it, you'll lose it. So that used to be the rule at the federal level, but in 2010, they passed what we call portability at the federal level, which had been an idea that was kicking around since 1980 with Reagan. They couldn't figure out, like, how do we deal with this? Because we don't want widows being like bumblebees to flower and picking up exclusions from deceased husbands, you know. So finally Congress got around to it. 2010, they said, look, if you don't use all of your $15 million exclusion, you can take the unused exclusion from your deceased spouse and tack it onto your basic exclusion of 15 million, so you might have a 20 or 30. You know, I had a client who, I think the exclusion amount was about $11 million, and the wife died first, and she left everything to the husband, marital deduction, and she didn't use any of her exclusion, and then he died second. So but fortunately, because of portability, we just tacked it on to his estate. And so we, you know, and because the concept was with Congress was, hey, you should be able to, you shouldn't have to do all this gerrymandering of your assets so that you use it. You know, we'll give you the portability. If your spouse doesn't use it, you use it. And in 2015, when I worked on the estate tax under the Shumlin administration, I tried to get them to have portability at the state level, but they said, it's not revenue neutral. You know, I don't know how they came up with that, but so that's our thing. But you can plan around that. We get our clients a $7 million person to give $2 million to the other spouse, so they both have $5 million. If either of them die, we can use up the exclusion. But that's, you know, totally within the boundaries of the tax system.
Are there any language changes that you would recommend for this bill as it's written right now?
No, I think I sat on the committee that drafted it, and we went through it pretty carefully, and so I think it's a pretty good statute to go.
The only thing that I would want to change is the just if redundant is the severability clause. We do already have that in statute, that kind of a blanket severability clause.
Severability, okay.
Isn't that? I think it's one.
Yeah, it's in Title I.
215.
Yeah.
So, I think that's just technical.
Yeah, I'll point out, I think it is like the 4th section. It's very sly, and it says, we're not replacing the common law here. So it took the Uniform Laws Commission, this is a standard provision in all the Uniform Acts, it's saying, hey, even though we're like the Uniform Trust Code, we're filling in some of the gap, we're making statutory changes here, but the common law is still in place, except to the extent that we've overridden it with our statute. But if there's anything outside there, the common law is still in place. And that's what we need in this act too, is that, so that you can do your common law disclaimer, even though it's past the 9 months, there may be gift taxes, but most people won't care.
Senator Rose?
I appreciate your thought that we can take out the severability clause, but generally don't we put things in, don't we talk about severability clauses when we're worried that something in the bill may be unconstitutional? So what is in this bill that we're worried may be unconstitutional?
Oh,
I think
no.
that's a thing we.
The Uniform Laws Commission puts in every single uniform law.
Okay.
Yeah, it's just, standard for Uniform Laws
That's flash
Commission.
for me, because I'm like, we never talk about doing that unless there's something unconstitutional, like.
Okay, yeah.
Yeah, so-
So, no.
Okay.
Alright. So, Eric, if you don't mind taking up the severability piece of this.
Right.
That'd be good, and then we'll figure it out.
Right, can I say one thing?
Yes.
There was an email from Matt that was recommending one technical change that said that the committee noticed a potential ambiguity in 4105.
Right, I remember I was on an email chain.
It's on the page of the bill of introduction, 4105C, so it'll be page 4.
Oh, incapacitated
Yes,
child? Yeah.
line 15, take out or incapacitated.
We don't know about that. We can.
And it was circulated among the committee, and they all said, yes, it's fine. Okay, it's a good change.
Thanks.
Is there any other recommendations?
No, it's just the one.
Okay. All right, so we can probably vote on this either Friday or when we get back to town meeting, unless some new information arises that is problematic, but I don't know if that'll happen.
But we don't have to make the crossover date?
No, we do, it's the 12th.
That's the week following.
Oh, that's 13.
Yeah.
Following 13, okay. I always thought it was town meeting day.
Weekend.
Okay.
But maybe I'll ask Chair Cummings if it's a finance.
Finance has next week.
No, I know, but this bill. If,
Oh, I see.
Just to take a peek and
Wanna
see if it
see,
should,
yeah.
would go there.
yeah.
Bloomer might also be a
Or
good person
Bloomer,
to check
yeah.
in with, because sometimes they have a sense that a bill might need to go to finance or appropriations, that once it gets to the committee, they're like, why is this here?
It actually happened this week.
So one point I would make is that what's happened is that we passed this 1978 Act in '86. And what happens is with the Uniform Access, issues percolate up, And so this is just a modernization of an act that we already have. And it's just tweaking it down the edges as far as what we do. It's not a big major change.
We want to make sure we ask.
Got matches. All over the report.
Maybe I don't want to go to finance. I don't have to do both of them.
You've got feet in many different areas, it could be a great bill.
I just think Bob's going to do a really good job at it.
Well, thank you, Mark,
Okay.
for your testimony, and we appreciate it.
Okay.
We
Yeah,
will-
Thank you.
Good.
I foresee this coming out of our committee.
Yeah, me too.